Good morning and welcome to another presentation brought to you by Denied Truth. This seminar or webinar will be a multi-part series dealing specifically with council tax as it applies to people in the United Kingdom. There is more than enough information to deal with, and I've broken it into three parts. This part specifically will deal with legal arguments as to a potential defense against council tax. The second presentation will deal with the actual summons and the paperwork from the court, and the third portion will deal with dealing with bailiffs. Before we can proceed, there is a legal disclaimer which I must present here, and basically the site which you obtain this information from cannot be held responsible for your use or misuse, or your lack of understanding of the information presented, or your ability to present this information in a legal and lawful manner. Every attempt is made to make sure that the information is correct, up to date, and error-free, but ultimately it is the responsibility of the viewer to do his or her own research and verify the information provided is being used in a correct fashion and appropriately. Council tax has a number of statutes which regulate its authority or its lack thereof, and we will go through the legislation listed here. This is broken down into primary and secondary legislation. I will explain each as we go through the slide. It should also be noted that a PDF file of these specific regulations and their applicable sections has been provided for you so that you may use them if you need to in dealing with council tax. The first act of the current government was the Act of Parliament. It's shown here on the first paragraph, if you will. What this act in essence did was dissolve the old forms of government and established the two houses of Parliament which we know today. Notice I said Parliament, not Parliament. So the Act of Will and Mayor is the foundational document which set up the monarch and the crown, and basically is our form and structure of our current laws. These similar rules apply in other countries as well. However, we go beyond the primary legislation and we'll be discussing secondary legislation. So for the purpose of this presentation, these rules apply only to people within the UK and potentially in Scotland as well. You will note that at the top of this slide, if you will, there is a seal, a monarch seal or a corporate seal. Okay? It's called the coat of arms. You will find that coat of arms in every courtroom in England, except for London, which has its own jurisdiction. Now, it basically simulates or emphasizes that the court is an operation of the crown or an extension arm of the crown. So any court which operates outside the legal provisions that are set forth within this presentation are in fact violating your rights or the statute or the act. An act and a statute is one and the same. Okay? It's synonymous. You can say Act of Will and Mayor, or you can refer to it as a statute. And there may be some debate on that from certain people, and for the purpose of this presentation, it's not relevant. But you will note that it is called the Act of Will and Mayor, and part of the ways down, you will see where the words were repealed in the Statute Law Revision Act, 1948. So is it an act? Is it a statute? At this point, who cares? The second thing that the government did, which was the second act of Will and Mayor, was to establish a Bill of Rights. This is not the entire Bill of Rights. It just emphasizes that the subject has rights. And it usually starts out, as most acts from Parliament, which is the crown, start out basically the same way. And thereupon the said Lord's spiritual, temporal, and commons pursuit to the respective, and then it carries on with whatever. Assembled full and free and representative, the nations taking in most serious consideration best means of obtaining the ends the aforesaid though in a place as their ancestors have usually done. So this is telling you, in this case, the Bill of Rights is recognizing your ancestors and your previous history. Okay? It says asserting their ancient rights and liberties. So therefore, the Bill of Rights recognizes prior ancient traditions, if you will. It also says dispensing of power and late dispensing of power. These two provisions within this act or this statute recognize that they're getting rid of the old government and putting in the new government. Now it also says levying of money. And basically it states here, if you read, and it specifically says, without the grant of Parliament, okay, for a longer time than is necessary, shall be granted, is illegal. So if a court says, well, they're acting under Parliament immunity, or they're doing it on behalf of the Crown, based on this very statute or act, no, they aren't. Because Parliament is the Crown, and Parliament is the two houses of government, which were established in 1688 with the first Act of Will and Mar. If we go on to the Coronation Oath, 1688, in brief summary, what this does is it says that every person that takes the crown or operates for the crown will take an oath of allegiance. And that oath is still held today by everyone that assumes the throne and assumes the position of the ruler within the monarch. This very fact states and proves that we're still operating under the British monarch system. And therefore, the fundamental rules, or primary legislation, is still relevant to today's case law. The oath of 1688 goes on further. It says the oath is to be administered to all future kings and queens, verifying what I stated earlier. If we go on to the Act of Settlement, I've highlighted a certain 2 paragraphs, more or less, and it says it's the birthright of the people, and all kings and queens shall ascend the throne to this realm ought to administer the government of the same, according to said laws, and all of their officers and ministers ought to serve them respectively, according to the same. This is establishing again the fact that the government must operate, when it makes laws or when it enforces laws, to these fundamental rights, okay? And it goes on further to say that all the laws and statutes of the realm securing and establishing the religion and the rights and liberties of the people, okay? And it says it may be ratified. Now, that ensures now that every law or every statute, every legal proceeding must conform to these basic fundamental principles of law. This is called primary legislation, and this was created by the Crown way back when, 1688 to 1700. There are additional acts that should be reviewed. However, in the term of simplicity, I will only go through the basic ones required for our case against council tax or our defense against council tax. Now, it also says, as we've indicated earlier, that it has to receive royal assent. Well, it is my understanding and belief that royal assent ceased to be a legal requirement. Basically, it was and now it's a formality of the law. Therefore, any laws which do not receive royal assent, or at the very least do not conform to these fundamental rules of primary legislation, are in fact null and void. And that applies to all cases, whether it's to deal with council tax, whether it's to deal with HMRC, whether it's to deal with a property standards issue, whether it's to deal with a traffic stop, I don't care. So, with respect to council tax, you will generally be brought before a magistrate's court. And it says right in here, subject to the provisions of the Act when a complaint is made to the justice of the peace. And it carries on. What you will find if you do a request, or you call the court, or you write them a letter, is that the justice of the peace does not, at least generally, review your case file. What happens, and what has been conveyed to me in a few cases that I have reviewed, the local municipality issues a list of names of people which they believe are in default of not paying council tax. No reasons as to why they may be in default or if there's a particular circumstances has been established. And what generally happens then is the legal advisor for whatever magistrate's court that is dealing with your specific area will do is they will authorize the local council to issue a list of summonses bringing you to court. And it'll accompany some paperwork. This paperwork and this summons is covered in a secondary seminar or webinar, which will specifically go through the faults within those documents. However, as this is to deal with the fundamental arguments against council tax prior to getting those documents, we will cover those subjects in a later seminar. You can request information from the local government and or the local court through basically a DSAR, Data Subject Access Request. And they are obligated by law to provide you this information under the Data Protection Act 2018 and the Freedom of Information Act. When you make these requests, be sure that the request is relative to your specific case because you are the subject. Okay? If you read section 173, it says alteration of personal data to prevent disclosure to data subject. You, for all intents and purposes, are the data subject. So if you receive information which is incomplete, does not address your concern, is blacked out, or is in some way obscured, the controller or the person that handles those requests is in direct violation of the Data Protection Act, and you may seek legal remedies for the wrongdoing. And you can opt to do that, or you can simply ignore it, or you can make a secondary request to clarify anything which has been not specifically addressed. And it says clearly, the alteration, defacing, blocking, ensure destruction or concealment of information which would have occurred in the abuse of the request made, exercise of the data subject's rights, or a person acting in the reasonable belief that the person is not entitled to this information may block out the information. So as I stated, you have to verify and ensure that the information you request is relevant to your specific situation. This information is not, however, limited to just getting information regarding council tax. It actually can be used to get freedom of information on anything that the government holds information on. It could be legal procedures, things that are relative to a court case. It could be issues to deal with the National Health Service. It could be issues to deal with information regarding a crime that was concealed. But specifically for this case, we will deal with council tax. You could make a request to either the local county council or the magistrate's court. The Local Government Act, 1888, Section 78(2), in the second paragraph, under C, it says to exercise any jurisdiction under the Summary Jurisdictions Act or perform any judicial business or other act as a justice or justice of the peace. So this now becomes a second problem for the local municipality, because as I indicated earlier, the municipality or counsel submits paperwork to a court, the court authorizes them to write up and draft up a summons, and they issue it to you. Well, in actual reality, the court case is to be reviewed by a justice of the peace, as indicated earlier, and then the court is supposed to issue that summons. How is it now that somehow the local city council is allowed to issue a summons, which is supposedly a court document, when it is contrary to the Local Government Act 1888, Section 78.2, subparagraph C, where they're operating as a justice of the peace? That's the justice of the peace job, not the local council. So this is the first argument that could be used. The Administration of Justice Act clearly states any person commits an offense if they try to solicit funds, basically, and claim a debt under a contract, and or they harass you with demands for payment. So counsel, therefore, would have to prove their claim to you, and then only if you did not pay that council tax, and if they proved a legal and moral obligation, would they then have the right to bring you to court, such as if you breached a contract with the local municipality. But if there's no contract, then they have no claim. This gets further substantiated later. So if they do something which is false, and they make a false statutory declaration or other false statement, and it's not sworn or signed or done under oath, they are therefore in violation of the Perjury Act 1911, Section 5. Okay? You can read this as well as it is. It says, in the abstract, account, balance sheet, book, certificate, or declaration, entry, estimate, inventory, notice, report, or return, or other document. Well, what they provided you was a document, and it was a statement of account, right? So it was a report. And it's an estimate because they don't even substantiate how council tax is calculated. So with no cost breakdown, no proof of liability, they send you this document, and they make themselves out to be a court. So again, all these things are against them. Now also, under the Fraud Act, failing to disclose information. As I said, when a court case regarding council tax goes into court, it is reviewed by the legal advisor based on the information that I was able to obtain. Now, when you go into court, the legal advisor also conducts the court, but it is his or her job to notify the court and or you of any legal rights that you may have, any statutes or provisions which may assist you or may assist the court in rendering a determination. This, to my knowledge, has never been done. Okay? And they're failing to disclose this information to make a gain for themselves and or another, meaning the court. So therefore, they're in direct violation of the Fraud Act, Section 3, subparagraph B. Okay? And they dishonestly fail to disclose it under Section 3, subparagraph A, because they're under a legal duty to do that. That's their job as the legal advisor. So now the court is complicit or in agreement with the actions of the local municipality, the local council. So they're both aiding and abetting one another. That makes this case void. Now, under the Fraud Act, Section 7, it says making or supplying article for use in frauds. Well, all the documents they produced were supposed to be done by a court, yet it was done by the local council. So therefore, all the documents are guilty of being an act of fraud. Okay? So there's certain provisions or certain legal recourses for committing such an act. Now, when an act of fraud is done by an officer of the court, it is a more serious offense than if it's done by the regular individual appearing in court, especially, as I say, because it's the legal duty and obligation. So they are operating as an officer of the court, but they're also operating as a a member of the public, a public servant, if you will, and in reality, they're operating as an extension of the Crown, so they're violating the fundamental rules that we covered in the primary legislation. So they're holding a position in office. So legally, they are in breach of their position in office, a breach of their public duty. And because they're supposed to know these rules and know the laws, as is the court, they have what is known as a fiduciary duty to uphold the laws and have a fair and equitable trial. As a result, the paperwork that's supplied is fraudulent, and if you notify the court of this information and the fact that it's fraudulent for various reasons, and the court now disregards that, they are therefore complicit in an act of fraud which violates your entire proceeding, and anything that happened against you is null and void. We can see here in the Fraud Act 2006 liability of companies and officers for offenses by the company. So this clearly shows us now that we can use the Fraud Act against these municipalities or councils as it relates to council tax or any other government organization, as they're all companies. If we check the Security Exchange Commission and or Dun & Bradstreet, we can confirm that the majority of these government organizations are in fact for-profit companies. Further, I would remind the viewer that the Clearfield Doctrine also applies. Now, if we look at the Council Tax Administration and Enforcement Regulation 1992, which is generally the act that they use that says you are liable, you will find out that there was at one point a prescribed form for council tax. However, on October 1st, 2003, no form has been substituted. The old one was removed, and no other one was put in its place. So if there's no legal form for doing this, one could argue that, well, if there's no legal form, it's not valid. Because any court, regardless of criminal or civil or its location, always has a prescribed court form for various applications. This is to aid the court when they review documents, so they're not wondering what the heck it is they're looking at, as they want a clear and concise and set of conform rules or conform forms so that everything is simple. Now, Regulation 34 of the Council Tax Administration Act, Enforcement Regulation Act 1992. You will note that this thing does not have the court seal, if you will, or the coat of arms, as it's generally known, and in fact says statutory instrument. Now, if we go back to our initial slide, you will note in the initial primary legislation, it does make reference to statutes. All courts are statutory courts. A statute is defined as a set of rules that govern a corporation. The government is a corporation. It's the Crown. Therefore, those statutes apply to them and potentially also apply to you. There's a legal maxim in law which states, all are equal before the law and no one is above the law. Therefore, if they can hold themselves exempt from various statutes, which was established by the government to regulate and control them, then you have the same right. Because if all are equal before the law and no one is above the law, if they have an exemption to a certain regulation, then so do you. Now, it talks about enforcement, and it talks about all kinds of other things. But if you review this thing, you will find out that, in fact, you are not technically obligated due to a conflict of interest. Because you will find the Regulation Council Tax Administration Enforcement also gets its authority from another act. So one act is supporting another, but there's no real basis in law. Now, Section 34, Council Tax Administration Enforcement Regulation, the court shall make an order if it is satisfied that the sum has become payable by the defendant and has not been paid. This requires the council to satisfy the court of two presumptions. the sum has become payable by the defendant, which is usually you, and the obligation hasn't been paid. They don't do that because they just submit a blanket list and say nobody's paid, and they don't take into account any underlying circumstances for the reason for non-payment. You may be withholding council tax because you don't agree with expenditures that they have. You may be withholding council tax because you simply can't afford to pay their council tax at a certain point. They don't care. Now, Regulation 35, Council Tax Administration Enforcement Regulation 1992, says a single liability order may deal with a person and such an amount or aggrieved amount as mentioned in 34 sub 7 and 8. Well, that would require the court to issue a court file number. And when you would file paperwork, you generally would file a copy with your adversary, in this case, county council, and you would file a copy with the court. And you would file a certificate or affidavit of service. It's called a certificate of service in the UK. Now, this has never been done to my knowledge, and in fact, the court will instruct you to file paperwork with your adversary, with the county council. Therefore, you have no way to ensure that the court has even reviewed or seen the paperwork relative to your case. This creates a conflict of interest. If there is a conflict of interest in any court case, that is grounds for dismissal. Okay? So that's no good. You can't do that. Now, it says here under 35 sub 3, the amount in respect in which liable order is made is enforceable in accordance with this part and accordingly for the purpose of any of the provisions of Part 3 of the Magistrates Court Act, 1980, Satisfaction Enforcement. It is not to be treated as a sum adjudged to be paid by order of the court. So, if we look at Part 3, which we will get into in a separate seminar, that is the regulation regarding property, because some properties within a municipality are taxable, some are non-taxable, and some receive a discount. For example, a church generally does not pay taxes for some reason, and there are reasons for it. We can get into that at a different time. However, the most important thing is, because they put it in brackets, it says the Magistrates Court Act 1980 is not to be treated as a sum adjudged to be paid by order of the court. So the court has no authority to order you to pay council tax, according to what this states. Now, because slavery is illegal, and because there is no legal provision to charge council tax, and the actions of charging council tax are a violation of primary and secondary legislation, anyone who tries to impose said fine on you, or anyone else for that matter, would be guilty under the Modern Slavery Act 2015. Okay, person is guilty of an offense under Section 1 and 2 is liable upon conviction of indictment to imprisonment for life, which means those persons, whether it's the county council, whether it's the magistrates, or whoever, tries to do something which to make you a slave and or commits fraud or perjury on you or on the court is grounds to have the case dismissed. And you have a right to a remedy, as you have now suffered an equitable claim against you. And because the actions are an act of fraud, in actual fact, fraud destroys all that it touches. And we will go through a second seminar, webinar, which addresses legal maxims. It is highly suggested that the viewer goes through that seminar and extracts from it all in any statute or any maxim which in fact aids your case. You also have the right to review and include case law. However, the maxims will give you approximately 35 to 40 arguments which may be presented as evidence in your endeavor to alleviate yourself from council tax. This presentation by no means covers all and every scenario. However, we have set up a Denied Truth group on Telegram for people who wish to discuss this and many other subjects, and in this case, specifically council tax. It is helpful if everybody contributes and we share alike in all information that comes forward. We only learn by doing, and we can learn from others. This is the purpose of this Denied Truth Telegram group. I hope this information was useful, and I look forward to everyone participating in the Telegram group, which is not specifically restricted to council tax, but in fact deals with all legal issues that are currently under review. There is a separate seminar, which covers the creation of the Telegram group and lists some, but not all, of the potential issues which we can address. If you have a specific issue that you would like to address, please email the deniedtruth@yahoo.com address shown on your screen. I look forward to learning, and anyone who thinks they know all and everything about the law or about anything is generally incorrect. We will learn together, and it is my hope that with this group we can further expand everyone's knowledge and seek a remedy which is beneficial to all. I thank you for your time listening to this presentation, and I look forward to making further presentations on a variety of subjects in the near future. Thank you for your time.